Thank you.
That sounds great. Thank you, Chris. So I can start briefly with an introduction. As some of you may know, my name's Meagan Vestby, and I'm a committee member of this year's FDI moot problem. So I'm very excited to hear how all the teams have chosen to argue our moot problem and how these arguments have progressed to this point of the global rounds. So excited to hear your arguments on that. And briefly, for a background of my practice, I'm an international trade lawyer for the government of Canada. My work basically consists of litigating Canada's trade disputes on trade remedy issues and negotiating free trade agreements on behalf of Canada. So with that, I'll defer to one of my co-arbitrators. Maybe we'll start with Leng Sun.
Thank you very much, Meagan. Hi, good afternoon, morning. I'm not quite sure where you are, but very pleased to meet you online. I'm a senior counsel of the Singapore Supreme Court. I practice as counsel. I'm also a chartered arbitrator, so I sit as arbitrator as well in chambers called Duxton Hill Chambers. I used to be in a large law firm, Baker McKenzie, and from one of the largest law firms in the world, I've gone to the other extreme to be solo, practicing as a UK-style barrister and arbitrator. Look forward to hearing you afterwards. Thank you. And Chris?
Good morning, afternoon, evening, wherever everyone is. I'm Christopher Tahbaz. I'm a partner in the law firm of Tabaz and Plimpton and a member of our International Dispute Resolution Group based in New York City. I also serve as our firm's general counsel. When I am not representing clients or representing my firm, I also sit as an arbitrator. I spent many years working in Hong Kong and have worked in many other parts of Asia. In fact, just before this we started, I was reminiscing with my co-arbitrators. I believe the last time I served as an arbitrator in the FDI moot was in the Asia Pacific round in Seoul a number of years ago. I'm very sorry we're not all together, but very happy to be virtually all with you today and look forward to hearing your arguments.
Thank you, Christopher, and thank you, Leng Sun, for your introductions. Before we get started, I think I can turn to the parties now and ask them if they've agreed on how they'd like to proceed today.
Madam President, the parties have agreed on the order of speaking as well as the durations. For the first phase of the proceedings, it will be respondent 1, followed by claimant 1. And under the second phase, it will be claimant 2, followed by respondent 2. In terms of speaking time, claimant 1 and claimant 2 will be speaking for 19 minutes and reserve 1 minute for the rebuttals. For the respondents, they'll be speaking for 18 minutes and reserve 2 minutes for the rebuttals.
Okay, understood. So I have the respondent team speaking for 18 and 2 and the claimant team 19 and 1. Okay, with that cleared up, I don't believe there's any other housekeeping matters, so we can get right to it. The respondent first speaker, the floor is yours.
Madam Chairperson, members of the Tribunal, a very good day from this side of the world. My name is Grace Jelimo, and today I appear on behalf of the respondents in this matter between Vema Holdings and the Federal Republic of Mekar. In the next 18 minutes allocated to me, I'll make submissions on the first and second claims respectively. Members of the Tribunal, in Mekar, where I come from, we like to use proverbs. And my proverb for today is that a camel cannot pass through the eye of a needle. It is important to note that only a thread can pass through the eye of a needle. We are here today, members of the Tribunal, because the claimants made bad business judgment which eventually led to their downfall. Surely, an investment treaty cannot be an insurance policy against bad business judgment. With this backdrop in mind, I'll make 2 submissions. That one, this Tribunal does not have jurisdiction over the present claims, And 2, in the unlikely event that this tribunal finds that it has jurisdiction, then it should accept the amici submissions of the external advisors to the CPRU and reject the amici submissions of the CBFI. To support my first argument, I'll make one broad argument that this is a state-to-state arbitration. And to support this argument, I'll make 2 arguments. That 1, Vema Holdings is acting as an agent of the government, and 2, Vema Holdings is performing essentially governmental functions. To this end, I shall begin. The jurisdiction of this tribunal is enshrined in Article 2 of the Additional Facility Rules, as well as Article 916 of the SEPTA. This provides that for a claimant to have standing, then they must be a national of a contracting party, and under the SEPTA, they must be an investor. We are here today because the claimant is masquerading as an investor, yet it is a state. We shall rely on the brochure.
I'm sorry to interrupt you there. You're saying Vema or Kaylee Airways is masquerading as a state, but they're incorporated, they have shareholding documents. Isn't that mean by just de facto they can't be a state, the fact that they're a corporate entity?
The fact that they are a corporate entity means that they may not be a state. However, it is our submission that they are masquerading as a state. This is because the state, they are acting as an agent of the state and they are performing essentially governmental functions.
So are you making the argument that the claimant is a state-owned enterprise or is a state? Is there a distinction there?
Yes, there is a distinction that a state-owned enterprise is one in which the state has a controlling interest, in which it enables the state to perform activities, public activities, separately from its functional activities, which is the case herein. So our argument is that the claimant, which is a state-owned enterprise, is performing essentially governmental functions and is acting as an agent of the government. To this end, we shall rely on the Broch's test, which is a functional test, and it provides that a government-owned corporation should not be excluded from being a national of a contracting party unless it is acting as an agent of the government or is performing essentially governmental functions.
Where does the Broch's test come from, counsel?
Indeed, Madam Arbitrator, the Broch's test comes from the preparatory works of the convention, and it was formulated by one Mr. Aaron Broches, who was the first ICSID Secretary General and one of the key principal drafters of the convention.
So my concern here is that you've rightly identified that the Broch's test comes from the travaux of the ICSID convention, but we're tasked today to apply the additional facility rules. And from what I can see, unless you can point me in the opposite direction, is that the additional facility rules and the SEPTA do not have an explicit prohibition for state-owned enterprises. So why should the Broch's test trump what the parties have explicitly agreed to?
The Broch's test should be used before this tribunal. This is pertinently because one, it is being used in the preparatory works of the convention that is pursuant to Article 25, which are similar provisions to Article 2 in regards to a national of a contracting party. Additionally, pursuant to the VCLT at Article 32, the travaux préparatoire can be used as a supplementary means of interpretation.
Okay, counsel, but VCLT Article 32, when they're talking about supplementary means and they're referring to the travaux, is that the travaux of the convention that was drafted? Or can you use supplementary means or travaux rather to interpret a completely different convention? Like the additional facility rules are a completely different set of rules. Is that how Article 32 of the VCLT is supposed to work?
Article 32 of the VCLT provides that it is the travaux préparatoire of the convention. However, we would like for this tribunal to apply it here because we are interpreting similar provisions, that is in regards to a national of a contracting party, which was being outlined at Article 25 of the convention. And in this particular case, we are trying to interpret the Article 2 of the Additional Facility Rules. Therefore, this would be a guide since both of these disputes are under investment dispute settlement. To this end, we submit that one, Vema Holdings was acting as an agent of the government, and two, Vema Holdings was performing essentially governmental functions. In the case of BUCG versus Yemen, the tribunal noted that this test is a disjunctive test. So I would like this tribunal to take notice that because this is a disjunctive test, we need only prove either of the above as the respondents, unlike what the burden of proof before the claimants is that they need to prove both of these so that they can qualify. For us, we need only prove one of the above because it is a disjunctive test. Vema Holdings is performing essentially governmental functions. This is in regards to the activities they were being involved in. The tribunal in Mafizini versus Spain stated that a governmental function is one that is essentially reserved to the state. We submit that they were performing functions that are essentially reserved to the state. To this end, I will guide this tribunal to paragraph 28 of the Statement of Uncontested, page 28, pardon me, at paragraph 5. If this tribunal could move with me to that. In the interest of time, I will summarize it. Before that, I need to contextualize this so that we can understand that indeed, Vema Holdings was performing essentially governmental functions. At paragraph 5, we see that Bonuru consists of 109 islands, and only 4 of these islands are major islands. To this end, these 4 islands are the ones which have important healthcare facilities and educational facilities. Therefore, this is why mobility rights are so important within the context of this moot and within the context of the functions that Vema Holdings is performing. Again, we see pursuant to Annex 1, which provides for the Constitution of Bonuru. We see Article 70, mobility rights. The Constitution of Bonuru is at page 41, paragraph 1430. It provides that the government shall guarantee mobility rights. Members of the tribunal, it is so peculiar for one to find mobility rights being codified in a constitution. And indeed, it is even more peculiar and surprising for one to find Article 70, or rather the Constitution, being in a memorandum of association of a company. In this particular case, the peculiarity is that the memorandum of association of Vema Holdings has provided for one of its functions. If this tribunal can move with me to paragraph 40, to page 44, at paragraph 1520. We see at Article 3H, one of the key functions of this entity is to assist in developing the aviation industry as well as the civil aviation infrastructure in accordance with mobility rights, Article 70. The courts of Bonuru have interpreted this right to be a positive obligation to the state. That is pursuant to Annex 2, that is at page 43.
So, Counsel, can I ask you just a clarifying question? You're connecting the constitutional right that Bonuru has to why Vema or Cali Airways performs a government function, but it's unclear to me that Cali Airways flies routes within the territory of Bonuru. Could you address that for me?
We submit that Kaili Airlines is an international airline, and therefore it continues to transport people not just within Bonuru, but it transports people to and from. And actually, pursuant to Article 70, at page 41, if this tribunal could move with me to that page, every citizen of Bonuru has the right to enter, remain in, and live in its territory. We submit, members of the tribunal, that a subsidiary of Kaili Airlines, that is Royal Nanyang, is the one which is performing these activities. However, it is important to note that Royal Nanyang has 100% ownership, and they are subsequently just similar airlines. To this end, we submit that this is an international airline, and therefore it was transporting people from and to Bonuru within Mekar and also in Bonuru. And we see then that it does not matter that the host state or the home state is different, because this is a sui generis case, because we see it is an airline company and it is transporting people all over to that end.
What I don't understand, I'm sorry, Chris.
No,
you
go
want to-
please. Go ahead,
What
Leng
I
Sun.
don't understand is how you draw the link to the constitutional right for transportation or mobility, which is a right of the citizen. To turn that into argument that the company Venma is a state performing governmental functions, just because there are certain rights of transportation. Just for example, water is a right of a citizen. Does it mean that every bottling company becomes an agent of the government?
To this end, we submit that the court's interpretation provide that the mobility rights are a positive obligation to the state, and a governmental function is one which has been reserved for the state. To this end, this governmental function of mobility rights has been reserved to the state because the geographical nature of Bonuru is one which can limit the mobility rights. The peculiarity then is that under Article 3H of the Memorandum of Association, which is the constitution of Vema Holdings, it has provided for one of its key objectives is to enhance these mobility rights pursuant to Article 70.
Thank you. I believe my
Council, sorry, thank you. Council, is Kelly Airways necessary to Venma Holdings providing transportation within Bonuru? In other words, if we accept your argument that Venma Holdings is engaged in a government function by providing mobility within Bonuru, is it necessary for Venma Holdings to use Kelly Airways in order to fulfill that function?
If I may give a clarification first, Kaili Airways is centered in Mekar and it was doing these functions in Mekar. And if you could kindly repeat for me the question there.
Well, that's exactly my question. Kelly Airways is functioning in Mekar primarily, not in Bonuru, correct?
Yes.
So what I'm trying to understand is how the ownership and operation of Kaili Airways facilitates the accomplishment of a government function within Bonuru, which seems to be the crux of your argument, as I understand it.
And if I could just add, the Constitution says in Bonuru, it has a territorial scope to it.
Indeed, if I may submit that actually this is an airline company and therefore it is a sui generis case because it is transporting people not just within Bonuru, but also from Bonuru to Mekar. And indeed, there has been an acknowledgement that it has helped to improve the tourism sector because it was helping to transport people to and from Bonuru and also within Bonuru and Mekar. To this end then, I will submit that Vema Holdings was acting as an agent of the company. And before I move to that, if I may clarify, actually, we see that it is under the Caspian project. The Caspian project, we see, if I may give an analogy of the China Bells Road Initiative, whereby we see a project that is being made by China to facilitate the road and to help other countries to build their infrastructure. In this particular case, we have the Caspian Horizon 2021 project, which is being used by the government. And actually by this project, we see that Kaili Airlines is benefiting, or rather Vema Holdings is receiving subsidies. That is at paragraph 28. It is receiving subsidies from this project. And actually this shows that the government is facilitating it in performing governmental functions. To my last limb, I will submit that Vema Holdings is an agent of the government.
Council, before you move on, I was just thinking about your argument on the subsidies. How is this distinguishable? The fact that Bonuru gave subsidies to Kaili Airways and the Caspian project, different than any airline operating in the world as a strategic industry? Airlines normally benefit or receive subsidies from their host governments.
We submit that in this particular case, unlike other airlines who just act for commercial purposes and not governmental functions, in this particular case, they were receiving subsidies, especially in the hard economic times. And actually, from paragraph 28, we see that Vema Holdings was the first to receive these subsidies. So the difference is in that other airlines just receive because they are just commercial airlines.
But how do we know that Vema, sorry to interrupt you, how do we know that Vema or Kali Airways wasn't acting commercially?
We submit that the commercial functions might be there, but they are auxiliary. It is a sui generis case indeed, because the main function of this airline is to perform the mobility rights and not just the commercial services. To this end, then, we shall submit that Vema Holdings was acting as an agent of the government. The test of agency has been made in Article 8 of the ILC Articles on State Responsibility. This provides that for an entity to be liable from the state, then they must be acting under the directions, the instructions, or the control of the government. We submit that Vema Holdings was acting under the directions, instructions, and control of the government. If I may guide this tribunal particularly—
Counsel, so I'm following your argumentation. Do you need to make an argument on control if you have made an argument, if we're with you on state agent?
Yes, I would need to make an argument on the control in order to show that indeed the government had controlling interest and was controlling this agent. And if this tribunal may not, this is a disjunctive test. And in the event that you are not convinced by the governmental functions, then you would need to look at the agency.
But if we were convinced by the, I'm not saying we are, but hypothetically, if we were convinced, would we have to look at?
You would not have to look at it, but for the benefit of my client, I will need to prove both of them in the event you are not. To this end, then, we submit that Vema Holdings was acting as an agent. One, we submit from paragraph 28 that voting is by majority. And we see that from the voting, that is at paragraph 3, if this tribunal is with me, we acknowledge that as the last sentence, we see that for some meetings, Bonuru's representatives formed a majority, but we see that for every meeting, Bonuru's representatives were present. To this end, we see then that the shareholding, or rather, sorry, the directorship is mainly being controlled by the Bonurian representatives. And to this end, the government has a high stake of control. In the interest of time, I will summarize the consequent fact that is at page 46, that there is one non-executive director who is appointed from the Ministry of Tourism. To make matters even more interesting, we see that they operate unprofitable routes. That is at page 55 from Miss Misty's interview. She says that going home has actually been easy because they are operating these routes between Mekar and Bonuru very cheaply, or rather they say not profitable for Kaeli Airways. All this show that the government had interest and the government was controlling this entity such that it was acting as an agent of the government. To this end, then, we submit that Vema Holdings was acting as an agent of the government and it was performing essentially governmental functions. Moving on then, in conclusion, we submit that this tribunal does not have jurisdiction over the present claims. And if today this tribunal is to determine that Vema Holdings has jurisdiction or has standing, then it would be detrimental because each and every other state-owned enterprise that is so closely interlinked with a state would have legal standing. Moving on to my second submission, we submit—
Counsel, I'll just let you know I have you at 20 minutes now. So will you be requesting an additional minute to conclude? Well, how would you like to proceed?
Yes, if I may request for an additional minute to sum up my arguments. In regards to the amici submissions, we submit that while this tribunal should accept the amici submissions of the external advisors to the CPRU, the same should not be granted to the CBFI. We submit that the CBFI should not be granted, first because they bring no novel arguments before this tribunal. Essentially, they do a repetition of what the parties have stated. And as was stated in the case of Suez versus Argentina, a new perspective is different from repetition of what the parties have stated. Secondly, they lack independence because of their association with Lapras Capital Limited. And lastly, we submit that the external advisors to the CPRU should be admitted. We acknowledge that they have brought a matter on the question of rational legis, something that is not within the scope of this dispute. However, we submit that it touches on the question of corruption and public interest, which is of importance before this tribunal. And in any case, the preamble of the SEPTA has provided that one of the key objectives of the SEPTA is to combat bribery and corruption. Therefore, this tribunal should admit the amici submissions of the external advisors to the CPRU and reject the amici submissions of the CBFI. Thank you. It has been an unbridled pleasure appearing before you.
Thank you.
Thank you.
Okay, now we turn to the claimant first speaker. The floor is yours whenever you'd like to start. Oh, you might be on mute. I see. Okay.
Oh. Good
You're
evening,
audible
Madam
now.
President. Yeah. Good evening, Madam President and other members of the tribunal. My name is Caleb and I act for the claimant, Vema Holdings. Speaking together with me today is my co-counsel, Ryan. Members of the tribunal, I'll be speaking for 19 minutes and I respectfully reserve 1 minute for my rebuttals. I'll be making the following 3 submissions before this tribunal. First, that this tribunal has jurisdiction to hear the present dispute because the claimant is not an agent of the Bonnery State, nor is it discharging an essentially governmental function. Second, that this tribunal should accept the written submissions filed by the consortium. This is because the submissions are likely to be unique and its participation will not unfairly prejudice the parties to this dispute. Finally, we invite this tribunal to deny the written submissions filed by the external advisors. This is because it raises a new jurisdictional objection that, if permitted, would unfairly prejudice the parties to this dispute. Moving now to my first submission on jurisdiction. This tribunal does in fact have jurisdiction to hear the present dispute. We agree with the respondent that in order for this tribunal to have jurisdiction to hear the dispute must be between a state and a national of another state. So it necessarily follows that if both parties to this dispute are states, this tribunal will not have jurisdiction. Similarly, we agree with the respondent that in determining whether a party qualifies as a state, the appropriate test to be applied is the Brochi's test. However, we submit that in the present case, the claimant is neither an agent of the Bonnery State, nor is it discharging an essentially governmental function.
Before you turn to those arguments, counsel, sorry to interrupt, do you concede then and agree with the respondent that the text of the SEPTA and the additional facility rules prevent a state-owned enterprise from having standing in this dispute?
Madam Arbitrator, we do not agree with the respondent that state-owned enterprises do not have standing under SEPTA to be heard before the dispute. The definition of an investor under SEPTA is very clear, and we meet this definition. Instead, the question before this tribunal is whether or not the claimant, as a state-owned enterprise, qualifies as a national under Article 2 of the ICSID Additional Facility Rules. Now, let me apply the Brochi's test to interpret the national requirement. Moving now to the first limb, the limb of discharging an essentially governmental function.
Before you move on, I'm still thinking about your response to my last question. So your interpretation of the SEPTA, for example, does not prohibit the standing for state-owned enterprises. And if your answer is yes, why?
Madam Arbitrator, the SEPTA clearly does not prevent state-owned enterprises from bringing a claim.
But wouldn't if we were to interpret the provision in the SEPTA to include standing for state-owned enterprises, would that not broaden the definition of national or enterprise investor beyond the scope of the common intention of the parties and to keep it investor state?
No, Madam Arbitrator. This is because Article 9.1 lays out a very clear definition of an investor. It defines an investor as an enterprise of a party, and it subsequently defines an enterprise as an enterprise that is constituted or organized under the laws of that party. The claimant, Vema Holdings, is incorporated in Bonnaroo, a party to the SEPTA. We clearly meet this definition. And even if I was to take Madam President's argument at her highest, that we need to consider the alleged intentions of the parties, it is clear that when we apply the Vienna Convention of the Law of Treaties, it is generally accepted that we give primacy to the express wording of the treaty. We meet the express definition of an investor, and therefore we are standing under SEPTA. The question before this tribunal is whether we qualify as a national. In this regard,
I'm taking your argument there, and this is my last question on this topic, I assure you. Do you know if the past SEPTA, I understand, is replacing an old bilateral investment treaty between Bonnaroo and Makar?
Correct, Madam
Bilateral investment treaty had an explicit prohibition against standing for state-owned enterprises. You would agree with me, I think. Does this bilateral investment treaty still have force between the parties?
No, Madam President, because the SEPTA is meant to replace this previous bilateral treaty between Makar and Bonnaroo.
But even is that true, legally, does that affect whether or not the bilateral investment treaty still has force? Sometimes free trade agreements or bilateral investment treaties are negotiated and signed, and there's a sunset where you can have an awkward situation where multiple standards apply at the same time. And so I'm wondering if it is true that the bilateral investment treaty, previously the original, let's call it, is still in force. Are we not required to take acknowledgement or acknowledge the prohibition for state-owned enterprises under Vienna Convention, Article 31, as a relevant rule of international law between the parties?
I take your concern, Madam President. If I may quickly address this, Article 1.6 states that the term of the previous bilateral treaty will cease to have effect on the date of entry into force of this agreement. Given that the bilateral investment treaty previously no longer has any legal force, we only need to consider Article 2 of the Additional Facility Rules for the purpose of this dispute. Now, moving on to apply the Brochie's test. Members of the tribunal, it is our position that the claimant was not discharging an essentially governmental function. A party discharges an essentially governmental function when it carries out functions of a public character, normally exercised by the state on the state's behalf. So an example given in the IOC articles on state responsibility is that of a private security firm hired to operate a prison. In that instance, the firm's act is basically an exercise of the state's power of detention on the state's behalf. So, just to emphasize, members of the tribunal, the issue before you today is whether or not the claimant is discharging an essentially governmental function. And to determine whether or not it was discharging an essentially governmental function, we do not look at the entire spectrum of activities that the claimant may undertake. Instead, as found by the tribunal in BUCG, to assess whether a company is discharging an essentially governmental function, we need to look at the specific actions of the company that are relevant to the dispute, not all of its activities. So in the present case, we do accept that the claimant partially assists the government in fulfilling its constitutional obligation by providing air travel to Bonnaroo citizens.
So you can see that they do contribute to the constitutional right, even despite the conversation that we had with the respondent on the matter?
Yes, Madam President. We do accept that the claimant does assist the Bonnaroo government in discharging Article 70 mobility rights. However, this Article 70 obligation, as rightfully noted by the respondent and Madam President earlier, is fulfilled using Royal Nanyang Airways. The respondent noted this earlier in her arguments. However, just to emphasize the nuance of my argument, members of the tribunal, the inquiry under this LIN is specific. So the question before this tribunal is not about Royal Nanyang Airways. It's about whether the claimant, by investing into KLE Airways, by operating KLE Airways all these years, did so to fulfill a governmental function on behalf of the Bonnaroo state. And on the facts, our position is this: the claimant was not doing so, and in support of this, we cite two key reasons. First, the claimant, by investing into KLE Airways, was essentially a commercial actor acting for profit. And we can see that it was a commercial actor since its investment was driven by an essentially commercial motive. Members of the tribunal, may I refer you to page 31 of the record? So at paragraph 23, at lines 1025, if the members of the tribunal have found the reference, we look 2 lines below line 1025, which states that Cayley's contracts with Finac International Airport are highly lucrative and offers unparalleled access to Mecca, and that the claimant was keen to take advantage of this commercial opportunity. Members of the tribunal, what these lines tell us is that the claimant, by buying over Cayley Airways, did so with the intention of taking advantage of a commercial opportunity. This means that its bid was driven by the desire to acquire the commercial advantages that Cayley Airways enjoys. Members of the tribunal, its act of investment therefore was not done on behalf of the Brunei state. It was done because it wanted to make a profit. Its investment therefore should not amount to the discharge of an essentially governmental function. And second, we can confirm this reading of the claimant's commercial capacity from the fact that the claimant was privatized. Privatization shows that the government was making an active effort to distance itself from the company. Now, if the government truly wanted the claimant
Counsel,
to...
how is that? We also see Bonoru increase their share percentage to 55% after the initiation of this dispute. So how is that reconcilable with what you just said?
Members of the tribunal, sorry, Madam President, if I may turn your attention to page 40 of the record. At paragraph
Just to clarify,
65,
you're saying the evidence shows that Bonoru was making an effort to distance itself. And I'm just challenging that with the fact that they actually increased their shareholding.
Yes, I understand your concern, Madam President, and let me prove to you why this is not the case. So at paragraph 65 on page 40, at line 1410, starting at the phrase, on March 2021, Bonoru implemented a bail-in program that allowed it to increase its shareholding to 55%. This is the incident that Madam President is mentioning. This tells us that the state only gained a majority shareholding in March 2021. Now, if I may refer this tribunal again to page 2 of the record, right at the start. At paragraph 4 of the notice of arbitration, at the first line, starting from the phrase, Mecca was notified of the dispute on 15th November 2020. And so members of the tribunal, what this tells us is that the incident that Madam President mentions occurred after the present proceedings were initiated. And as a matter of international law, it is generally recognized whether or not a party has standing in an international legal dispute is made by reference to the date on which such proceedings were instituted. This is the approaches taken by numerous tribunals such as CSOB, ENVR, TINVR, so on and so forth.
So are you asking us to just ignore this fact?
Madam President, I'm not asking this tribunal to ignore this fact, but the fact that the state subsequently increased the shareholding is irrelevant to this tribunal's finding on jurisdiction in the present instance. Now,
Counsel, can I ask you a slightly different question? Even if let's assume that the government had completely, completely privatized Benma Holdings, why would that necessarily be preclusive of Benma Holdings executing an essential government function? Isn't it the case that in countries throughout the world, essential government services have been privatized in the past 10, 20, 30 years of our lives? Well, just because postal services and water companies in many countries have privatized those services, why would that be preclusive of the company performing an essential government function?
Mr. Arbitrator, I note your concern, but we do not look at the act of privatization in silo. What I invite this tribunal to do is look at the facts in totality. Look at the fact that the claimant was acting with a commercial intention. Look at the fact that the claimant was privatized and that there was no significant control exercise over it when it was making its commercial decisions. When we put all these facts together, it draws the fair and likely inference that the claimant was not discharging an essentially governmental function in the present instance, and thus we invite this tribunal to make such a finding. To quickly move on to my next submission, the submission on agency. Members of the tribunal, a company becomes an agent of the state where it acts under the control, direction, or instruction of the state. So this happens when the state directs and controls the specific instance being complained of. So members of the tribunal, the question before you is this: did Bonnaroo direct, control, or instruct the claimant to make an investment into Kaylee Airways? And on the facts, this is clearly not the case. This is for two key reasons. First, as mentioned earlier, the state only owned a minority stake at all material times, and it could not exercise significant control even if it wanted to. And second, the state's influence over the claimant's board was limited to a singular non-executive director. Madam President, I see that you have a concern, and let me quickly address it rapidly. The respondent earlier asserted and discussed the quorum requirements. However, I would like to highlight to the members of the tribunal that on the facts, they do not tell us whether or not how often such instances occur. And given that the claimant only owned about 30% of the the government only owned about 30% of the claimant's entire shareholding, instances where the government was able to exercise a majority over the claimant's shareholders will be exceedingly rare. And given that the facts do not say anything else, we can assume that this was not the case. Accordingly, I invite this tribunal to find that no control was exercised over the claimant in the present instance. Given that the claimant was neither discharging an essentially governmental function, nor acting as an agent of the Bonnaroo state, this tribunal thus has standing to hear the present dispute. Moving now to admissibility. This tribunal must now decide whether to admit or deny the submissions filed by the consortium and the external advisors. I will mirror the respondent's submissions on this issue, so I will address the consortium submission first. As rightfully noted by the respondent, in order for a tribunal to admit an amicus submission, the amicus must bring a different perspective from that of the parties. The respondent earlier asserted that this would not be the case. However, this is clearly untrue. The respondent, the consortium, is likely to make a different submission from that of the parties because the parties are incapable or unlikely to make a similar submission to it. Let me prove to the members of the tribunal why. First, the respondent will not make a similar submission to that of the consortium because the consortium's submission is disadvantageous to its case on jurisdiction. The respondent's submission is that state-owned enterprises should be denied standing to be heard before an exit tribunal. The consortium submission is that denying state-owned enterprises standing will negatively impact investment flows. So members of the tribunal, as a matter of common sense, the respondent clearly will not make a similar submission to that of the consortium. Now, to address the elephant in the room, what about the claimant? We submit that the claimant will not make a similar submission to that of the consortium either, because the claimant, at its heart, is an airline holding company. The investment concerns prevalent in the aviation industry are unique, and they differ greatly from other aspects of trade.
It's interesting. Sorry if I can interrupt you again. It's interesting how you've characterized their argument, the amicus arguments, that they're really just talking about how the dispute or the outcome of dispute, or sorry, to be more specific, our decision on jurisdiction will affect investment flows. How is that then within the scope of this dispute?
Madam President, the consortium submission on investment flows is within the scope of the dispute because it highlights the negative impacts and the policy ramifications that this tribunal's decision will have if it renders an adverse decision on jurisdiction. And this is highly relevant because the purpose of the exit convention is to allow and promote investment, cross-border investment, given that the consortium submission raises the likelihood that this tribunal's decision may undermine the spirit of the exit convention. The tribunal must give weight to its submission. Members of the tribunal, I know that my time has elapsed. May I have an extra minute?
I have you at 18.5 minutes. So if you want an extra minute, I can take you till 20, or that will take you until 20 minutes.
Yes, Madam President, thank you so much. If I may quickly sum up my submission, on the part of the claimant is an airline holding company, and by virtue of its specialized perspective, it cannot make the consortium submission with the requisite expertise nor knowledge. Accordingly, we invite this tribunal to find that the consortium submission will be sufficiently different so as to merit its participation. Now, to address the final submission, that of the external advisors, members of the tribunal, we agree with the respondent that a tribunal can consider the legality of the investment as part of its inherent powers to find its own jurisdiction. Legality is an important part of international public policy, and of course, it must be considered. However, our position is this: if this tribunal wishes to consider the legality of the investment, it must hear the parties first, not the amicus. So, if the tribunal wishes to consider legality, it should inform of the parties of its decision to do so, and then give them time to prepare submissions on it. Only then may this tribunal allow an amicus curiae to come in and make submissions to supplement what the parties have already submitted to this tribunal. Accordingly, at this point of time, it is inappropriate to consider the amicus submission filed by the external advisors. If I may be of no further assistance to this tribunal.
I just have a question to clarify. I note your time. So so I understand your argument. You don't take issue with the fact that this amicus may or may not raise a jurisdictional issue. If it does, you don't take issue with that per se. It's that your client hasn't had an opportunity to make submissions on the issue.
Yes, Madam President, that strikes at the heart of my submission. This is because if we permit an amicus curiae to come into this dispute and start raising objections on the fly, which neither party to the dispute has adequate notice of, it will unfairly prejudice their procedural rights and deny them the opportunity to be adequately heard before this tribunal. Accordingly, we invite this tribunal to deny the amicus submission at this point of time. If I may be of no further assistance to this tribunal, I hereby conclude my submissions.
Thank you. I don't see any questions from my fellow arbitrators, so I believe we can move to rebuttal. Respondent 1, I'll start your time whenever you begin.
In rebuttals, I'll make 3 major rebuttals. First, in regards to the case of BUCG versus Yemen, the respondent's counsel stated that, the claimant's counsel stated that they should look at the particular instance. I'd like to make a key distinction between BUCG versus Yemen and this case. Particularly, this is a sui generis case, and unlike in BUCG, where we see that there was no mobility rights in the constitution, we see that this is a sui generis case because also this was a construction company, and here it is an airline company, which therefore gives extraterritorial activities because it is an airline company. Second, in regards to Royal Nanyang, I'd like to give a factual clarification that is at page 29, paragraph 10. Vema Holdings is an airline company incorporated in Bonuru with 100% ownership in Royal Nanyang. Therefore, we cannot be blind to the fact that the claimant is the same as Royal Nanyang. Vema Holdings has 100% in Royal Nanyang. Secondly, in regards to the instance of majority shareholding, which directly infers to the directorship, we submit that pursuant to page 89, that is the procedural order number 4, if this tribunal can move with me there, a factual clarification, we see that the Commonwealth of Bonuru is the only governmental shareholder in Vema Holdings. Additionally, no other shareholder has more than 7% stake in the company. We submit that surely, members of the tribunal, it is so hard to bring all these 7% people or the shareholders to agree to one decision, unlike Vema Holdings, which has, despite it being 31 to 38%, this is a majority because the 7% shareholders taking of other shareholders, they cannot come to an agreement in regards to this decision making. To this end, that would conclude my submissions. Thank you.
Thank you. Claimants or rebuttal?
Members of the tribunal, just one point in rebuttal. On jurisdiction, the respondent's rebuttal comes down to this. It invites the tribunal to ignore the specific instance and instead consider the broader functions of the claimant. It says that BUCG is a sui generis case. However, in the RC articles on state responsibility, which the respondent cited in her arguments, it says clearly that we focus on the specific action being complained of. Members of the tribunal, I hereby rest my rebuttals.
Thank you. Okay, let's turn to the merits. Claimant 2, the floor is yours.
Good evening, Madam President and esteemed arbitrators. My name is Ryan Lim, representing the claimant, Dema Holdings. Members of the tribunal, these are the facts of the case. The claimant was an investor who single-handedly transformed an investment in the respondent's territory from a struggling company to a profitable air carrier. However, all these efforts went to waste when the respondent took advantage of a currency crisis to cripple this investment through heavy-handed and rigid policies. The result, the state's acquisition of the investment at a mere fraction of its original value. In light of this, I will be canvassing two broad submissions in these 19 minutes. First, that there has been a breach of fair and equitable treatment. And second, that the claimant should receive fair market value compensation for this breach of FET. Turning to my first submission, the respondent has breached the standard of fair and equitable treatment. As a starting point, Article 9.9 of the SEPTA imposes an obligation on the respondent to accord treatment that is fair and equitable to the claimant and its investment. Article 9.9 further lays out what kinds of acts breach this FET standard. In the present circumstances, it is our submission that the respondent has breached this standard of FET in three of these ways. First, that the claimants have acted arbitrarily. Second, that they have denied the claimant justice. And third, that they have acted in a discriminatory manner. Moving to my first point, the respondent has acted arbitrarily by forcing the claimant to keep airfare prices low in spite of severe inflation. First, it's crucial for us to define exactly what arbitrariness means. While the SEPTA itself does not define arbitrariness, we submit that one of the ways it can be characterized is where a measure inflicts damage on the investor without serving any apparent legitimate purpose. This was the definition of arbitrariness adopted in the seminal case of EDF and Romania, paragraph 303, and has been subsequently applied in numerous exit cases, such as Bear Creek Mining, Stati and Kazakhstan, Antin, and so on.
Counsel, so so let's just go right to the airfare caps. The CCM imposed them. Whether that was legitimate or not, we can talk about. But the holding of the airfare, or I guess the maintenance of the airfare cap is what you're taking issue, and that it's happening at the same time as the MON inflation.
Exactly, Madam President. You're struck at the heart of my argument.
So if that's the case, then is it not the CCM's purpose for doing that to bring the market share of K-Lead down below 40%?
Madam President, you are exactly right to say that. And the facts tell us that the original purpose of the caps was to prevent it from earning supra-competitive profits. In other words, to make sure that the claimant will not earn excessively high profits. And we accept.
How is that arbitrary if there's a clear objective, it's outlined in their statutory regime? It seems legitimate enough to me.
Yes, Madam President, we accept that it was a fair measure with a legitimate purpose at the time. But the onset of the currency crisis changed the situation entirely. And it tells us, the facts tell us that the MECA currency took a nosedive and that the respondent was in the midst of a currency crisis. And this would mean that in order to survive, the claimant would need to raise its airfare prices to keep pace with this hyperinflation. But because of the airfare caps, it could not raise its price. And to answer Madam President's contention, while yes, there was still the purpose there of keeping the claimant's market share low, but legitimacy also requires an element of proportionality. And our submission is that these measures were disproportionately punitive to the purpose that they set out to do, which is merely to keep the claimant from earning excessively high profits. Rather, what ended up happening was that the claimant was unable to even cover our costs. And this led to significant losses for the claimant, which went above and beyond this purported purpose that they went out to do. And so, Madam President, so members of the tribunal, we submit.
I'm missing the connection between proportionality and the fact that the CCM achieved exactly what they set out to do and what they are allowed to do in their domestic statute.
Well, Madam President, to answer your concern, this was the opinion of the tribunal in Saluka, where they interpreted this legitimacy requirement under arbitrariness to state that where a policy, for a policy to be legitimate, it needs to bear reasonable relation to its objective. So our submission here is actually that the retention of the caps, which was an active decision on the part of MECA, served no legitimate purpose because it was disproportionately punitive to the purpose of the measure.
Well, at what point in time are we assessing the objective of the measure? Is it when the measure is imposed? Because at that time there was no currency crisis. Or does the state bear some sort of responsibility to completely review one measure, all of its measures, to make sure that it's maintaining reasonableness or proportionality? It seems burdensome.
Well, Madam President, you are absolutely right to say that. But the facts tell us that the claimant, in fact, brought this to the respondent's attention multiple times. And not only that, but it wasn't even to consider a removal of the caps, but a mere adjustment of the caps to accommodate the inflation. So our contention is that they have acted arbitrarily by actively choosing to retain these caps in the midst of a currency crisis. And it's for this reason we submit they have acted arbitrarily. Moving to my next point, we submit that the respondent committed a denial of justice by refusing the claimant the right to be heard. A classical case of denial of justice occurs when the claimant is denied proper access to the courts. And this is noted in the case of Krederi and Ukraine at paragraph 451. In the present case, the claimant was effectively denied a fair chance to be heard on the issue of the airfare caps. And this is for two reasons. First, their claim was unfairly thrown out at an interim proceeding. I invite the tribunal to turn with me to page 86 of the record. Page 86 of the record.
Why is it important that it is an interim decision?
Well, Madam President, if the whole tribunal is with me here at page 86, it tells us here that the air caps was, that the decision on 15 June 2019 was a decision on a motion for injunctive relief. And it also states that the judge simultaneously dismissed the applicant's case on the merits by way of summary judgment. Now, the claimant accepts that Macquarie law allows judges to summarily dismiss claims where there is very little chance of success on merits. We fully concede this. But in order to do this, the judge would at least need the benefit of being able to consider a party's argument on the merits. To answer your concern earlier, Madam President, in the present case, this was only an application for temporary injunctive
Counsel,
relief.
I think there's actually an inconsistency there. When you're hearing something in a summary fashion, are you hearing all of the arguments on the merits?
No, Madam President, and that's the point we're making, that this was not a hearing where the claimant presented on the merits or was prepared to present on the merits. For all intents and purposes, the claimant was only aware that this was a temporary stay on the airfare caps, and it only realized that a decision was being made on the merits several months later when Judge Benduza released his decision on claiming that exercising his power to dismiss the claim on the merits.
I guess my concern is that you conceded that under the domestic law, that's perfectly acceptable to do so.
Yes, Madam President, but in order to do so, the judge would at least need to consider the case on the merits, which was not what the claimant was making submissions on. And that is our precise point, that the claimant was denied a proper right to be heard because it was not given the adequate notice to that it was presenting the case on the merits. And despite this, it was, and even more egregiously to add to that fact, page 38 of the record tells us that the claimant was left with no further appeal. Members of the tribunal.
Counsel.
Yes, Mr. Tabaz.
Counsel, I'm sorry, is it your submission that claimant had no opportunity to provide even a summary case on the record, which I believe would be consistent with an interim proceeding. Is there anything in the record that supports that contention?
Yes, Mr. Tabaz. To make it abundantly clear, the claimant was allowed to make submissions on the request for the temporary stay of the airfare caps. So perhaps in such a scenario, the main consideration would be the damage that the caps were inflicting on the claimant's investment. But what is our contention here is that the claimant was not allowed to present a case on the actual merits of keeping the airfare caps on. And our point is this, that the claimant, we are not asking the tribunal to decide the case on the merits. All we are asking for is the tribunal, is for the claimant to have the right to be heard in a fair arena, one which the respondent has failed to afford us. And it's for this reason we submit there has been a denial of justice.
So denial of justice is I think you'd agree with me, an incredibly high threshold. So is there anything else you can point to, any other measures that we have the ability to look at to maybe assess the measures together?
Well, Madam President, I think it is our position that taken in these two facts in conjunction, that first, the claimant was denied the right to be heard, and second, the claimant was not even allowed a proper chance of appeal. These two facts alone are sufficient to constitute a case of denial of justice.
Okay, so my follow-up question is then, if we're not with you that this is a denial of justice, can we consider the measures you pointed to when you're making your arguments on arbitrariness and consider a cumulative violation of the fair and equitable treatment standard?
Exactly, Madam President. We rest on the strength of our written submissions for whether it is a cumulative breach, but we fully concur with you that in any case, even if we don't meet this singular standard of denial of justice, we, in any case, taken in conjunction, all these measures amount to a breach of FET. Moving on to my last point, the respondent acted in a discriminatory manner by refusing to grant KD Airways subsidies under its relief scheme. Discrimination pertains to any action that treats a party differently from other similar parties without objective justification. On the facts, subsidies were given under the emergency relief scheme to other foreign airlines such as Starwings and Jetgreen. The rationale, that KD was a state-owned company and therefore enjoyed advantages over these companies. We submit this was an objectively unreasonable justification for two reasons. First, KD had in fact received lower subsidies from their home state than these foreign airlines did. And second, they had in fact ceased to receive subsidies a full 2 years before the emergency subsidies were meted out. And to add,
sorry, Council, were there other airlines that were foreign airlines that were not given the subsidies?
Yes, Mr. Chan. There was in fact another airline, Larry Air, but that detracts from the point here. Our point is that KD Airways was discriminated against, and Larry Air in fact could have been discriminated as well. But what we are focusing here on specifically.
Well, I think the point that my co-arbitrator is making is there's not a differential in treatment when you compare K-Lead to Larry Air. So how can we just cherry pick the airlines that we're using as the comparator group here? Would this not just stretch the fair and equitable obligation beyond what's intended here? In my mind, the state has to retain some say in how it distributes its public funds.
Yes, Madam President, I understand your concern, but this was the ostensible justification that the bare fact that it was a state-owned company meant that it enjoyed advantages that made it unfair to grant its subsidies. And it's our submission that this justification was objectively unreasonable for the reasons stated earlier.
Is Larry Air a state-owned enterprise?
Yes, Madam President, it is a state-owned enterprise. And so to conclude, we submit that the claimant has breached the standard of fair and equitable treatment in 3 of these ways: arbitrariness, denial of justice, and discrimination. And having established this, we submit that the appropriate standard of compensation for this breach of FET is fair market value. To clarify,
how much more time do you have? Can I just check with you, because I don't know if I should ask question and take up your time.
Mr. Chan, I have 5 minutes left, so if you have any questions, I will entertain them.
I want to backtrack a bit on your argument about the denial of justice, because it seems like if you're saying the court made a wrong decision or the court was wrong on the law, and the fact that there's no right of appeal is also a matter of law, how does that cross into state responsibility or breach of FET.
To make things clear, Mr. Chan, the claimant is not asking the tribunal to this is not merely a wrong decision. This was a refusal of a right to be heard, which is a right sacrosanct to natural justice and falls under Article 9.9 of the SEPTA, which imposes an obligation for the respondent not to deny justice. So we submit that taken in conjunction, this right of refusal of the right to be heard, alongside the lack of appeal, this amounted to a denial of justice. If I may move on.
Before
Yes,
you move to your
Madam President.
compensation argument, sorry, in the SEPTA, I don't have the article at hand, but I believe I remember correctly that there is a right given to the state to regulate.
That'll be Article 9.8, Madam President.
Thank
Is
you.
that what
And
you're
one
referring
of
to?
the reasons that they're able to regulate is for consumer protection. This seems exactly the factual scenario that it falls within the state's right or McCar's right to regulate for consumer protection.
Well, Madam President, in the same article, it tells us that it also must be in pursuit of a legitimate public policy outcome. And we submit that within this standard of legitimacy, as I've canvassed, there needs to be a certain element of proportionality, because we cannot simply allow the state to impose punitive measures that, while ostensibly fulfill a legitimate purpose, inflict severe damage disproportionate to the purported purpose. If I move on quickly to my issue on compensation, we submit that there are two grounds for why fair market value compensation should be the appropriate ground. First, a plain interpretation of the treaty tells us that the tribunal is not obliged to award market value damages. There is nothing in the SEPTA that imposes an express compensation standard for breaches of fair and equitable treatment.
Well, where is fair market value in the treaty then?
In the treaty, Madam President, it is only mentioned with regard to expropriation.
Or sorry, market value.
Apologies, Madam President. It mentions it in Article 9.21. And all Article 9.21 tells us, is the tribunal like to flip there, at page 82 of the record.
Oh, you can just keep speaking so that.
Okay. Yes, thank you, Mr. Chan. All Article 9.21 tells us is that where a tribunal makes a final award against a respondent, the tribunal may award monetary damages at a market value. So, members of the tribunal, Article 9.21 is just a facilitative provision, and it does not impose an obligation, but merely guides the tribunal. We submit instead that the tribunal should be guided by the principle of full reparation, which mandates that fair market value compensation is appropriate for situations where breaches of FET lead to severe devaluation and ultimate acquisition by the respondent. We submit this has been fulfilled in the present case, since the investment was severely devalued and was ultimately acquired by the respondent, and we thereby submit that fair market value compensation is the right standard.
Where does the
In any
principle?
case, yes, Mr. Chan.
Because you were answering the question on fair market value, then you pointed out that it's not in there, and then you bring it in by the principle of full reparation. So where does the principle of full reparation come from?
Well, Mr. Chan, the principle of full reparation is an instance of customary international law. And under Article 1.3 of the SEPTA, it tells us that the parties should apply the relevant provisions of the treaty in consideration of applicable rules of international law. So we submit that the tribunal should be guided by the principle of full reparation to influence its decision to impose fair market value damages for this breach of FET.
Why is the explicit use of market value in the treaty not the parties contracting out of customary international law?
Apologies, Madam President. Can you repeat your question?
Yeah, so you pointed that, or you identified that the parties use the words market value in the text of the treaty. How are but you want us to apply the fair market standard from customary international law. How is the market value standard, not lex specialis in this case, or the parties contracting out of customary international law?
Well, Madam President, to reiterate, and I know my time has elapsed, may I be given an extra minute to summarize?
Sure, yeah, I have it 19 minutes, so you have till 20.
Thanks, Madam President. To address Madam President's concern, our submission is that Article 9.21 does not, in fact, impose an obligation to award market value damages. All it does is facilitate the tribunal's awarding of market value damages. And in any case, members of the tribunal, we submit the claimant is entitled to most favored nation treatment under Article 9.7 of the SEPTA. This means that if better treatment is given to a third party in like circumstances, the same treatment must be given to claimant. In the present case, there is another BIT that between MECA and the third party state. And within this treaty, it tells that one of the provisions provides for fair market value compensation. And under this provision, tribunals have consistently awarded fair market value compensation. And we therefore submit that MFN protection allows us to import this standard into the present case and confer the claimant fair market value compensation. If I may be of no further assistance, this concludes my submissions, and I thank the Honorable Tribunal.
Thank you. Respondent. Whenever you're ready.
Thank you. Madam President, members of the Tribunal, good evening from this side of the world and good day to you all from wherever you're joining us. I appear on behalf of the respondents, the Federal Republic of Mekar. My name is Kevin Kipchirchir, and in the next 18 minutes, I shall be submitting under claim number 3 and claim number 4 to respond to the arguments submitted by counsel for the claimant. And to mirror the arguments by the claimant, I shall be, for the interest of convenience, submitting that, firstly, the Federal Republic of Mekar has not violated Article 9.9 of the SEPTA, and pursuant to the exception under Article 9.8, the Federal Republic of Mekar has a right to regulate. And under the fourth claim, I shall be submitting that the Federal Republic of Mekar owes no compensation to the claimant, and should any further compensation be given, the same should be based on the market value standard of compensation and not the fair market value standard. In Mekar, where I come from, we have the common boy who wants to cry wolf whenever they lead themselves to self-injury. And this is common in almost all homesteads. Similarly, in this matter, Madam President, members of the Tribunal, we have an investor who entered into the Mekari market, knowing very well that it was acquiring a company ridden with debt liabilities in an economy which was precipitating, and proceeded, interestingly, to pursue overambitious expansion programs, and that which led, as is the norm, to its downfall. Now, when it further proceeded to exercise anti-competitive measures and the state exercised its right to regulate, it was to cry wolf. Members of the Tribunal, to mirror the claimant's submission, we shall be submitting 3 interrelated arguments. That firstly, the Federal Republic of Mekar acted in an arbitrary manner. Secondly, the Federal Republic of Mekar granted justice to the claimant. And thirdly, the Federal Republic of Mekar acted in an undiscriminatory manner. Under the first claim, counsel for the claimant has submitted that the maintenance of the airfare caps was arbitrary. However, this is the danger of a single story. Members of the Tribunal, the investigation into Kaili Airways, the imposition of the airfare caps, and the maintenance of those airfare caps were based on strong, solid grounds and rational grounds. Members of the Tribunal, if I may guide us all to page 34 of the record, please let me know if you're with me. Paragraph 36 and 37, that CCM investigated Kaili Airways as a precautionary tool, given that its pricing strategies could push out all other smaller competitors from the market. And secondly, to prevent it from earning supra-competitive profits, it implemented the airfare caps. Now, members of the Tribunal, to take us even back further to give context to the investigation, may I guide us all to page 30?
Sorry, Counsel, I'm actually trying to understand the things that are said about the purpose behind trying to control or put a cap on the profits of Kaili Airways. Because on the one hand, there's this comment that Kaili Airways was being extravagant, ill-strategized business plans, and probably therefore not making very wise business decisions. And then on the other hand, you say that, well, we have to stop it from being too profitable. So I don't quite get what your purpose is. Are you trying to make it profitable or trying to make it not profitable?
Mr. Bicheta, quite I agree with you, but also on the contrary, we are trying to make it profitable, as is the way we treat all investors in our market. However, we need to treat all investors on the same lane, and this therefore should take it upon us to prevent an investor in our market from pushing out all other competitors. And this is expressly what we did by asking Kylie Airways not to collude with other Moon Alliance members. And if I may guide this tribunal to page 32 of the record, paragraph 25, perhaps to give more context. That is page 33 of the PDF. In paragraph 25, the CCM, while approving the Moon Alliance, asked them not to collude on huge competitive parameters. And this is what they did in paragraph 27, Madam President, members of the tribunal, the last line, line 1070. They colluded with Royal Nanyang in respect of launch access, terminals, IT platform, check-in operations, and code sharing. And if I may give an analogy of what code sharing is in the airline industry. Let's say today you want to fly from Geneva to Seoul, South Korea, and you need to make a stopover in Berlin, perhaps flying with Lufthansa and joining with Emirates. Through code sharing, it would allow you to fly without any flow to enter Lufthansa and personally connect with Emirates. However, when they enter into a code sharing agreement with their alliance members, it effectively locks out other companies from these connection flights, and therefore it will only be a Royal Nanyang Kylie affair that cannot be allowed to stand. And furthermore, members of the tribunal.
Well, I'm concerned because what you just described is common practice to all international airlines. Is it not? So are there any international, if that was the standard, would any international airline operating in CCM not be investigated?
Madam President, indeed, as noted also by the Organization for Economic Cooperation, sharing of terminals or IT check-in platforms are common, as airports are common access platforms. However, the aspect of code sharing takes into account what is called vertical integration or horizontal consideration of a company. And as persuaded in the Organization for Economic Cooperation round policy papers on airline alliances and mergers at page 28, these are grounds for collusion and can be grounds for investigation. Now, counsel for the claimant argued that the maintenance of the airfare caps with the MON currency was arbitrary. However, there's a context to this. If I may guide this the tribunal to page 35, let us consult the facts. Paragraph 39. Where the IMF rationalized this move that states need to stabilize their currency. And even we acted in good faith. Initially, we had accepted them to denominatize their airfare caps, their airfare with the US dollar, the most stable currency. However, with a need to stabilize our currency, we had to revert with the backing of the International Monetary Fund to the MON currency.
I think what you're, sorry again, I think what you're, well, I was going to say learned friend, but there's too English. What your colleague was arguing from the claimant was that it was a combination of both. You had your currency policy combined with the fact that you don't allow them to raise prices. And that made it impossible for them to be profitable. So it wasn't just the currency alone, but with the currency control, they needed to raise their prices. So that's what made it difficult for them.
Mr. Abichita, if I may guide us all to page 33 of the record, that there was a policy change that led to this situation, especially that there is influx of foreign funding. That is the footnote in page 33, not page 33, page 34, I beg your pardon.
Yes, I understand. That explains your monetary policy. But why didn't you let them raise prices? Especially since at paragraph 38, which was the page you pointed to us, you also said that CCM wanted to launch an investigation into Kylie's practice on price undercutting. That's why I have difficulty in understanding what's the consistent rationale of all these policies. You don't want them to undercut and you don't want them to raise price.
Mr. Bichetan, while they were undercutting on the one hand, on the other hand, they had an undue advantage from their state. And if I may guide this tribunal to page 89 of the record, where they are a consistent recipient of subsidies from their home state of Bunuru since 2011 under the Horizon 2020 program. And this gave them an upper hand in their dealings and also in their subsidization program and price undercutting. And on to the second submission made by claimant.
I have a quick question just on the issue of pinning them on. If we're with you that this isn't an issue of arbitrariness, does the state have any liability in terms of maybe other substantive obligations with forcing a denomination on investors? I'm thinking of performance requirements specifically.
Pardon your question, Madam President.
So you're looking at the MON just by itself, the policy decision to force the MON denomination on investors. Is that a violation of something else? Is that a different violation? Maybe not fair and equitable, but say, is this something illegal under international law? Maybe like a performance requirement that we should also be thinking about?
Not under the SEPTA or not under international ratified by MECAR at the moment, or under aviation industry or aviation law.
Thank you.
Thank you. And under the second submission made by counsel for the claimant, counsel submitted that they were denied justice by being denied the right to be heard in the Federal Republic of MECAR. However, this is not a factual truth. In page 36 of the record, paragraph 43, the matters that were filed by Kylie Airways was a matter for interim release to stop the airfare caps. And subsequently, in paragraph 54, page 38 of the record, Justice Van Duzer heard them on this very matter and rendered his decision, which decision was to refuse the interim reliefs to be granted. Now, members of the tribunal, this is not a court of appeal. I think that is fundamental to mention. And therefore, the mere disagreement by counsel for the claimant with the decision of Justice Van Duzer does not breach the high threshold to prove denial of justice before the courts of MECAR.
Counsel, if I may interrupt you, how do you respond to claimant's argument that they did not have an opportunity to provide argument on the merits?
If I may guide this tribunal to page 38 of the record, paragraph 52, that they were in fact heard on the matter that they had filed, that the matter was for interim reliefs, and were heard over 3 days, members of the tribunal. This does not happen everywhere, but a matter for interim reliefs to be heard over 3 days, they must have sufficient time to be heard by Justice Van Duzer. And in any case,
sorry, I'm not sure if you heard the question correctly or your opponent's point as well. You referred us to paragraph 54, but you see that at the bottom, after deciding on the stay, the court also considered a prima facie case on the merits and say that, to save precious time, the court also dismissed the merits. So are you saying that the merits were also considered in the course of the stay application?
And not entirely, but based on what had been filed and under Executive Order number 5 of 2019, Justice Van Duzer had the discretion to examine the evidence position and whether there was under the economic balance of the judiciary to consider whether the case had any further chance of success, which it did not. And therefore we submit that the claim for denial of justice is not reached. And if I may summarize in the interest of time, counsel submission under discrimination, we concede that we discriminated against the Vema holdings alongside Jet Green and Starwings. However, this is the danger of a single story. The discrimination was justified. If I may guide this tribunal to page 86 of the record, paragraph 6. While Kylie Airways was a consistent receiver of subsidies under the Horizon 2020 scheme since 2011, Jet Green and Starwing only received a lump sum in the years 2016. Members of the tribunal, the state of Mekar has the discretion to see who to grant their subsidies and when to do so. And given the poor economy of Mekar, this has to be exercised sparingly. And one entity already is receiving huge subsidies from its home state, it would be unfair to grant it extra subsidies in light and at the expense of other smaller corporations which have smaller entities. And in any case, in procedural order number 4, Kylie Airways had a staggering 40% market share, while the subsidy recipients had 5% market share. And on a fair analysis, the one who needed the most had to be given, which were the other entities. In light of the above, we submit that we had good reason to discriminate against the entities in the Mekari market. And onto the issue touched on by Madam President, we did have the right to regulate under Article 9.8, which is an exclusive right. And comparatively to the chapeau requirement in the GATT Article 20, we need proof that we regulated legitimately pursuant to the right to regulate consumer protection and did not violate Article 9.9 of the SEPTA. In light of the above, we submit that we regulated in the interest of consumer protection and did not violate either the arbitrary conduct under Article 9.9 or the discriminatory conduct under Article 9.9. In light of the above, we submit that the Federal Republic of Mekar has not violated the fair and equitable standard of treatment. Onto the argument for compensation if the tribunal has no concern. We are aware of the phrase, give to Caesar what belongs to Caesar. However, coincidentally, you should not give to Caesar what doesn't belong to them. Counsel for the claimant has submitted that compensation should be based on the fair market value. However, this is not the provision of the SEPTA agreement under Article 921, that is page 82 of the record. And page 82 is clear, and as rightly noted by Madam President, this is a lex specialis agreement and even also a lex posterior agreement. That when awarding compensation, this tribunal should only consider the market value except as otherwise provided for in Article 912. If the drafters of the SEPTA wanted that compensation be given based on the fair market value, nothing prevented them from indicating that for violations of FET, compensation be given on the fair market value. And they in fact excluded the operation of the fair market value by providing under Article 912 that the fair market value standard shall be for expropriation matters. And in any case, this tribunal cannot consider a more favorable treaty obligation under the Arakis Mekari BIT, given that under Article 99, page 76 of the record, 997, a most favored nation obligation cannot be invoked to request a more favorable treatment under the current provision. In light of the above,
why is that, counsel? I would just like to explore that a bit further. Why? So I take your point that the states have agreed on market value, but why they've also agreed on most favored nation obligations?
Indeed, we have to provide the context that the SEPTA was provided from, that in the previous Bonuru Mekar BIT, a lot of tribunals had awarded against Mekar and even Bonuru compensation. And I see I have a few seconds to end my time. Could I be given a discretionary minute?
Yep.
To make this case?
Yeah, everyone else received a minute, so you have till 19.
Thank you. We submit that under the contextual purpose and reading of the SEPTA, that the parties, having read onto the previous treaty tribunal compensation standards, wanted to exclude this tribunal from considering the fair market value. And in page 77, Article 997, provided that the provision of this article shall not apply to invoke a more favorable treatment accorded by either party under another treaty. Members of the tribunal, that is a clear exclusion by the drafters and by the parties to this treaty to prevent themselves from considering the most favored nation obligation. In light of the above, we submit that this treaty should not give to Caesar what doesn't belong to him. and should award no compensation, and should any compensation be given, it should be based on the market value standard. And also the pleadings or findings, we plead that this tribunal finds that it has no jurisdiction to make a determination in this matter. Secondly, admits the amicus submission by the external advisors to the Committee on Reform of Public Utilities. And thirdly, find that the Federal Republic of Mekan acted pursuant to Article 99 of the SEPTA and award no compensation or any compensation on the market value. And lastly, and importantly, members of the tribunal, when you retire to chambers to make a determination on this matter, remember, the critical matters raised by this case, the right to regulate by states, the overriding investor interest, and to balance them, and the advancement of investor law pursuant to your determination. And thank you for the time to submit before you. It's been a pleasure.
Thank you. So let's turn to rebuttal claimant. The floor is yours.
Members of the tribunal, just one point in rebuttal on the denial of justice. The respondent's case rests on the sole fact that the claimant was given a chance to give submissions. We absolutely agree with this, but a chance for what exactly? Solely the chance to submit on the matter of the temporary relief for the FAQs. In contrast, the respondent has pointed to no fact that shows the claimant was given a chance to present on the merits or were even prepared to present on the merits. Accordingly, the right to be heard was not upheld. They have been denied justice. This ends my rebuttal. Thank you, members of the tribunal.
Thank you.
Mr. Lim, I'm sorry, Madam President, if I may ask a question.
Yes.
Mr. Lim, is it your position that claimant was somehow prevented from making a submission on the merits in support of the application on interim measures?
Mr. Tabaz, to clarify, the claimant was only prepared to present on the temporary relief of the FAQs, but was never told they were supposed to present on the merits. All Judge Venduza did was to exercise his unilateral power to decide the case was without merit, which of course the case lacked merits because the claimant did not even present on the merits. Yeah, I hope this answers Mr. Tabaz's question.
Thank you.
All right, respondent, with Sir rebuttal.
Thank you, Madam President. I have one point for Sir rebuttal. Counsel for the claimant has submitted in his rebuttal that we do not give any fact to show that they were not heard or that they were heard on the hearing. However, we cannot hear a matter that has not been filed. And if I may guide this tribunal to page 36 of the record, paragraph 43, that is at line 1230, that on 8th of March 2018, Kelly's board voted to seek judicial review of the CCM's airfare caps. Now, either from any jurisdiction we come from, a common law jurisdiction or a civil law jurisdiction. Before you file a matter for interim reliefs, you first file the bundle of facts and then request the court to grant you an interim release as it considers the matters. And courts normally consider to grant you an interim relief before proceeding to consider the facts. And Justice Venduza, having had the parties on the submissions and considering the other facts, decided to dismiss the whole matter on its own merits. Thank you.
Thank you. Okay, congratulations, everyone. You could take a breath. That's the conclusion of the hearing. Before we get into comments and feedback, I think it's prudent if the arbitrators retire to the chambers and we can come back, or I know we have some time, so maybe we should give over general comments now. I'll defer to my arbitrators to see what they would like to do.
I'm fine. Do you want to give comments now or together after deliberation? I'm fine. If you want to give some general comments now.
Okay, yeah, we can do that. Christopher, do you have any opposition to that, or we can go and caucus first?
No, that's fine. That's fine.
Okay, so we'll proceed. I can just start. I'll break the ice with the general feedback. Brilliant round. I thought this round lived up to what it needed to be a finals. For the third place, the level of argumentation was great, and it's really interesting to see how the strategic choices in the arguments were made for each party to win the case in their minds. And because there's so many options or opportunities, or in this like choose your own adventure problem, really there's so many different ways to do it. And I've heard different arguments from both teams, and that's a thrill to me as being one of the problem authors. So thank you so much for that. I thought everyone's style, you can see, and this is another amazing thing about this moot competition, is you are starting out your advocacy or career. So it's so impressive to see how everyone's kind of developing their own style. Respondent 1, Grace, you are so easy to listen to, and you come across kind and credible, and these things are so great to hone these skills at a very early level. Claimant 1, you are so persuasive. You are so persuasive. You don't concede, and I love this. And you use something that I'm still working on in my practice. You said the question before you is this, and then you say, you go right to the point of the issue, and then why we win, 1, 2, 3, and that's just, how do you argue with that? That skill at that level is just so impressive. So congratulations. And Claimant 2, what do I have some substantive comments, but we'll avoid those. Fantastic pace, your tone, and you're so conversational in your pleadings, which I love that. I want to have a conversation with the individual pleaders, and that just, it's a style thing. It's not for everybody, but you wear it so well. So just keep that up. It's very enjoyable to hear your submissions. And Kevin, I think I'll be transparent. We saw, I believe I judged you and Grace in the all African round, but on the different side, hence why I wasn't conflicted out of this round. You have grown tremendously, and not just in your knowledge of the law, but your use and command of such a huge problem is no small feat. I am incredibly impressed by where you've come from just weeks even, and that just means you put in so much hard work, and that's really what it takes in real practice. So congratulations. I'll defer. Christopher, if you'd like to give some general comments.
Sure. I just a couple of comments. I thought the round was fabulous, and it was interesting. I have a very different perspective than Meagan. This is the first and only round I will see in this moot, so I'm much more listening to the structure of your arguments and your advocacy than focusing on the particular details. I guess the two things that really struck me when you all were most successful were, first of all, when you were being precise. I agree with Meagan that sort of identifying the most important questions, articulating those questions, and then telling the tribunal how you would answer them, I think is an incredibly effective strategy. I also really like, and Grace, that you all did this to some degree. Grace, I had a note that was particularly for you, identifying a theme that sort of that explained either your client's motivation or the other client's motivation in a truthful way, to talk about how the claimant's business judgments, their poor business judgments, led them to where they are today. I think it is, you don't want to make that your whole argument, but I think it's very useful to plant that seed at the beginning of the arguments. The other thing that I liked about all of your arguments was that they were all very authentic to who I think you all are. I think I heard you speaking in your own voices. It didn't strike me that any of you were pretending to be what you thought an advocate should be. You all had different voices. I loved the use of the analogies and the sort of the sayings at the beginning for both for Kevin and Grace's arguments. I thought that was it was a clever way to kind of engage. And somebody else, it might seem too cute or sort of artificial, but it fit both of you. And the same for Caleb and Ryan. I thought your style was very sort of crisp and direct, and it felt like I was actually listening to you speak as you would be speaking naturally. So and that's I think very important. So I thought really very impressive performances all around.
Well, I agree totally with my two colleagues. So there's not a lot for me to add, and I will not go person to person. But generally, congratulations, very well done. And I can't say that an experienced advocate would have done better. So it's very impressive. And I also do echo what has been said, that all four of you had very pleasant disposition, very conversational, and you could remain that way even under very probing, difficult questions. So kudos to you. One thing I noticed was how well all of you have managed to zoom into the key points in the brief time that you had, that you wanted to present. And that's no small feat. I don't see anybody going off tangent here. You have focused on what's important, and in advocacy, that's really crucial. The other thing, of course, I think it's a given that all of you have read up on the law very well. As you will find, you have already found in this MOOCs, and as you will find in real life advocacy, a lot of arguments will turn on the facts. And these are very good complex problems where there are difficult points of fact for both parties. And that's where the tribunal will have a chance to test you and ask you difficult questions. Sometimes it's not easy to answer them, but as I think you have seen from your experience, the preparation will go a long way. You must always think about the shortcomings in your own case on the facts, as well as the law, and anticipate what are you going to say. So to a large extent, you all have done that, I think, most of the time in answer to questions. So very well done.